Okay, let's unpack this. We're doing a deep dive today into, well, the judicial heart of an Indian state. The high courts. They're pretty powerful. We've got this stack of source material, constitutional articles, legal analysis, even bits from a Supreme Court judgment. Our mission, really, is to sift through it all and figure out exactly what these high courts do. What are their specific powers? Where do they come from?
Yeah, and understanding the high courts is, well, it's crucial. They are the highest court in a state, after all. They play this huge role for citizens, especially like protecting fundamental rights. And what's really interesting, something the sources point out right away, is that the Constitution didn't just invent them out of thin air. It actually built on quite a bit of history.
Exactly. That's what I found fascinating, too. It's not a clean slate. So we've got these articles, 215, 217, 225, 226, 227, 228, 235, lots of numbers, plus the analyses breaking them down, and that specific Supreme Court case snippet showing how it works in practice. It feels like a good mix, yeah.
Yeah.
Foundational stuff and real-world examples.
Definitely. So maybe starting with that foundation you mentioned, Article 225. What jumps out from the sources is this idea that the Constitution largely just preserved the jurisdiction and powers that the high courts already had. Before 1950 wasn't about starting over completely. It sort of grandfathered in a lot and then added things like jurisdiction over revenue matters, which wasn't always there.
That's really interesting. So less of a year zero situation and more like, okay, let's formalize and build on what exists. In Article 225, it also gives the High Court power to make its own rules for how it operates.
Yes, exactly. That's a key practical power mention, how they hear cases, how decisions are made. And the sources show how this Article 225 rulemaking power gets used for very specific things, like framing the procedures for handling election petitions. That Supreme Court judgment we have, the Kailash v. Nanku one, it talks about exactly that, how rules for election trials were slotted into the High Court's existing rule book made under Article 225. It shows that power in action, the nitty-gritty.
Right. Linking the big constitutional power to actual court procedure. Okay. And then there's Article 215. The sources say it makes the High Court a court of record. What does that mean, practically speaking?
It basically means two things. One, their official records are preserved forever, like as permanent evidence. They have lasting value. And two, as a court of record, they inherently have the power to punish someone for contempt of court, for disrespecting or disobeying the court. Though the sources do add that this contempt power is pretty serious. It's a summary power, so it's meant to be used, sparingly, only when really necessary.
Okay. And just quickly on the judges themselves, Article 217 comes up. What are the basics there?
Qualifications and retirement age, mostly. So to be a judge, you need either 10 years in a judicial post in India or 10 years as an advocate in a high court or multiple high courts, one after another. And the retirement age is 62. There's even a process if there's a dispute about a judge's age, the president decides, but has to consult the Chief Justice of India first. So quite specific.
Got it. So we've got the historical roots locked in by Article 225, the rulemaking, the court of record status under 215, judge criteria from 217. Now, let's really get into the core functions, the different kinds of jurisdiction the sources talk about. Original, writ, appellate, supervisory, control over lower courts, judicial review. It's a lot.
It is a lot of hats they wear. And starting with original jurisdiction, which, as you said, connects back to Article 225 for those historical powers, this is where a case actually starts in the High Court. It's not an appeal. The sources list specific areas where the High Court is the first port of call.
Like what kind of cases start right there?
Okay, so admiralty cases, shipping law, basically.
Right.
Those contempt of court cases we just mentioned. Election disputes for MPs and state MLAs. Matters concerning revenue collection. And critically, cases about enforcing fundamental rights. That's a big one for original jurisdiction.
Right.
Also, cases transferred up from lower courts if they involve a tricky question about interpreting the Constitution. We'll touch on that again with Article 228. Oh, and the sources also note that some high courts, Calcutta, Bombay, Madras, Delhi, specifically still have original civil jurisdiction for cases involving large sums of money, though they mostly lost their original criminal jurisdiction back in 1973 with the Criminal Procedure Code.
Okay, that's clear. So that's where they're the first stop. But maybe their most sort of famous power is the writ jurisdiction under Article 226. What do the sources say about that?
Well, they trace the idea of writs, habeas corpus, mandamus, certiorari, prohibition, quo warranto, back to the English legal system. That's where they originated. But, and this is key, the sources emphasize that the Indian Constitution, with Article 226, massively expanded this power compared to what little writ power some high courts had before independence. It's much broader now.
And here's something that really jumped out at me from the sources, kind of an aha moment. about Article 226. It lets high courts issue these writs not just for fundamental rights, which you'd kind of expect, but also for any other purpose, which means basically enforcing ordinary legal rights too. That seems huge.
It is huge, absolutely. That's a really significant expansion. And that distinction leads to a really interesting comparison the sources make with the Supreme Court's writ power, which is under Article 32. Both courts can issue writs for fundamental rights, but the High Court's power under Article 226 is wider because it includes any other purpose, those ordinary legal rights.
Right, so if my fundamental right is violated, I could go to the High Court or the Supreme Court. But if it's just an ordinary legal right, like a contract dispute or something, then only the High Court's Article 226 applies for a writ.
Essentially, yes, for seeking a writ remedy specifically. But here's the other side of that coin, another crucial difference the sources highlight. While the Supreme Court, under Article 32, cannot refuse to hear a case if a fundamental right seems violated, it's considered a fundamental right itself to approach the SC. The High Court's power under Article 226 is discretionary.
Ah, okay. So the High Court can say no, even if a right, maybe even a fundamental one, seems violated.
Yes, it may refuse to issue a writ. It's not an absolute guarantee for the citizen. The High Court weighs various factors, and there's also the territorial limit. A High Court's writs generally only run within its state boundaries, or if the cause of action, the reason for the case, arose there.
That discretionary aspect for the High Court under 226 versus the, mandatory nature for the Supreme Court under 32 for fundamental rights. That's a really key distinction to grasp. Okay, so we've covered original jurisdiction, the very broad writ jurisdiction. What about keeping an eye on the courts below them? That brings us to supervisory jurisdiction, Article 227.
Right. The sources call this the High Court's power of superintendence. It covers all courts and tribunals within its territory. And they're clear, citing cases like Waryem Singh, that this isn't just about administrative stuff like telling lower courts how to keep records or prescribing forms, although it includes that too, sometimes linking back to older laws like the 1861 Act. Crucially, it also includes judicial superintendents.
Judicial superintendents.
Yeah.
So they can actually step in and affect a lower court's judgment under this power. What's the aim of that, according to the sources? Why do they have this?
The core purpose is to make sure lower courts and tribunals operate within the limits of their authority, basically keeping them in their proper lane. It's about preventing them from exceeding their jurisdiction or maybe refusing to exercise jurisdiction they should be exercising or acting in some grossly improper way.
Okay, but how is that different from just appealing a decision or even using Article 226 to quash an order? It sounds like there could be overlap. How did the sources, like that Nagendranath Bora case mentioned, help clarify this?
That's a great question, and the sources do try to draw a line, though it can seem fine. They stress that the power of judicial interference under Article 227 is not supposed to be wider than under Article 226. So under Article 226, you might get an order quashed if there's an error apparent on the face of the record, a clear legal mistake. But Article 227 interference is theoretically more limited. It's focused on whether the lower body acted within its authority. Did it grab power it didn't have? Did it abuse its power? Did it wrongly refuse to hear a case? It's not meant to be used just to correct ordinary errors of law or fact. That's what appeals are for.
I see. So Article 227 isn't like a secret second appeal,
Yeah.
a backdoor to get the High Court to rehear the whole case and fix any minor mistake.
Exactly. That's not its purpose. The sources even contrast the remedies. Article 226 often just cancels the bad order. Article 227 can involve the High Court giving directions or even substituting its own order. But, crucially, only when acting within that supervisory role, correcting jurisdictional errors or abuses, not acting like an appellate court. And, just like Article 226, this power under 227 is also discretionary. You can't demand it as a right. It's used when the High Court feels it's necessary to step in.
That really helps clarify the specific sort of niche role of Article 227. It's about boundaries and authority, not just right versus wrong outcome. So beyond supervising decisions, do high courts have direct, administrative control over the lower courts?
Oh, absolutely. And that's under Article 235. This is fundamental for how the whole state judiciary, below the High Court itself, actually runs day to day.
What kind of administrative control are we talking about?
Well, the sources give concrete examples. The governor needs to consult the High Court for appointing, posting, and promoting district judges. That's the top tier below the High Court. And for all the other judicial officers in the state, civil judges, magistrates, etc., the High Court is directly in charge. Their appointments, postings, promotions, granting leave, disciplinary actions, transfers. It all vests in the High Court.
Wow, okay. So quite hands-on control over the personnel. And you mentioned Article 228 earlier about constitutional questions.
Yes, that's another specific power. If a case is happening in a lower court and a really significant legal question comes up that involves interpreting the Constitution,
Yeah.
the High Court has the power under Article 228 to withdraw that case from the lower court.
Mm.
It can then either decide the whole case itself or just decide the specific constitutional law question and send the case back down to the lower court with instructions on how to apply that interpretation.
And the rulings themselves.
Yeah.
Just like Supreme Court decisions are binding everywhere in India, High Court decisions are binding too, right? Within their state.
Exactly. Laws declared by a high court are binding precedent for all the subordinate courts within its territorial jurisdiction.
Okay, so let's try and bring this all together for you, our listener. We've seen how all these different powers, they're distinct, but they clearly connect, make the High Court such a central player. You've got the historical foundation and the rule-making power from Article 225. You've got the incredibly broad power to issue writs under Article 226, protecting not just fundamental rights, but ordinary legal rights, too. Then there's the watchful eye of supervision under Article 227, making sure lower courts stay within bounds. And finally, the direct administrative control over the state judiciary through Article 235. It really paints a picture of the High Court as, well, a cornerstone of justice and a key protector of your rights at the state level.
That's a good summary. And understanding these different layers, these different articles, helps you see how the whole judicial system fits together. You can see the different avenues available for citizens to seek justice or to challenge decisions or just to ensure the system is operating correctly within its own rules.
We've definitely unpacked quite a bit today about the High Court's authority. From those historical roots in Article 225 through the wide reach of 226 writs, the very specific focus of 227 supervision, and that crucial control over the courts below via 235.
Yeah, and reflecting on those nuances we discussed, like the discretion difference between Article 226 and Article 32, or that careful line Article 227 tries to draw between supervision and appeal, it really shows the kind of intricate, balanced system the Constitution tried to set up. It's not always simple, but there's a logic to it.
There is. And maybe, based on everything we've looked at from the sources, it leaves us with a final thought to chew on. We heard that the High Court's supervisory power under Article 227 is meant to be used sparingly, and it's discretionary. So does that inherent discretion ultimately strengthen its role, by keeping interference focused only on the most serious cases of jurisdictional error or abuse? Or could that same discretion potentially limit how effective it is as a consistent everyday safeguard for ensuring all lower courts are functioning properly? Is there a trade-off there? Something to ponder after our deep dive today.